Everyone, good afternoon, and thank you for joining on our webinar. We are just waiting for two more people to join in, and we'll quickly start off. So, in the meantime, let me give you a quick introduction to why we are having this session and what's the objective behind introducing a new offering from Altius. So, like most of you know, Altius is typically into investments, and we've largely catered to the private markets where we've had people invest into late stage pre-IPO private companies 3 to 5 years before their IPO, and that journey typically leads us to kind of invest in companies and then stay invested for the next 3-4 years, growing their wealth over time in a very sensible and logical manner. But what we felt is that during the entire wealth creation journey, the last leg, which typically everyone misses out, is on estate planning, right? So typically what happens is all through your life, you are saving, you are investing, you are ensuring that your investments are doing well. The investments are being tended to on an annual basis. But once all of that comprises into a sizable corpus, how we actually allocate that and how we actually deal with it at the end of our journey is what is also very critical. And what we realized is that most people do not realize this as a necessity until it becomes very difficult for them to do it. So it is actually better to do an estate planning when you are in control of things, when you understand where you would want to leave your accumulated funds, accumulated wealth, and how you would want to distribute your overall legacy. Now, so what we did is we worked for the last 6-7 months with multiple teams, law firms, to understand what typically goes into estate planning. And over the last 1 month, we've kind of developed an entire framework, which essentially allows us to help you better plan your future, better plan your distribution, better plan your legacy, and essentially have a very structured way as to what happens to your wealth, either when you are there in control of things or when you've maybe passed away. How does your family inherit? Who gets what? And to kind of assist with understanding all of this a lot better, we've partnered with Will Genie. So Will Genie was promoted by uh, people with very deep background in the legal space who had run law firms for a very long time and had specialized into succession and estate planning. And they had started a new vertical under the brand name of Will Genie, which allows people to build wills and define inheritances and also build family trusts. So on the call, we have Rahul Shah and Shrishti from Will Genie's team. And over the next 35-40 minutes, what we'll want to do is we'll want to understand from Rahul and Shrishti as to why estate planning is important. How does it help us to get into it early on? How do we kind of manage it on a regular basis? So I think creation of will is one thing, but how do you also kind of work on it on a regular basis, improve it, uh, amend your will basis your new realities, new family member addition, new assets which you're holding, and largely also help you determine which is the correct structure for you. Should you opt for a will? Should you opt for a joint will? Should it be a nomination? Should it be a inheritance planning? Should it be a family trust? All of that is what we'll try and cover in the next 30-35 minutes. Then we'll, as always, we'll try and keep a 10-minute Q&A for any questions that you would want to ask. So over to you, Rahul and Shristi. If you would want to give a quick introduction before you kind of kick it off, that would be helpful.
Sure, sure. Hello everyone, and thanks a lot, Abhishek, for the quick context. It's really helpful. So yeah, I'll talk a little bit about Will Genie, about in an introduction to Will Genie, and then sort of structure how the presentation is going to go. Right. We were founded in 2015 with the single focus of doing or planning succession in a planned manner. So from 2015 to till date, we've been working with multiple clients to figure out what is the plan that's a good plan for their families to ensure that they can do a very proper succession or an inheritance from that matter in the future. We are located in three locations physically: Bombay, Delhi, and Bangalore, and we are building a national brand to ensure that there's transparency, honesty in this section of the industry, which is probably not as much spoken about. As Abhishek rightly mentioned, growth of wealth is something that we all sort of look at religiously from time to time. But this last leg of protecting it probably becomes very, very essential, because as Indians, what we typically want to do is ensure that our children are at a place where, all of our efforts has been transferred to ensure that they have a better life. So with that thought in mind, Virginie has been set up and been going strong. With us on call, we have Shishti, Advocate Shishti, who has been with us for the last 2 years. Um, she takes care of she's a senior advocate with us who takes care of planning as well as drafting. So a lot of technical knowledge is something that she'll be able to share along the call as well. And the way we'll structure it is, first give you an understanding of why succession planning is important, then take you through wills in general. What are some of the myths that are prevalent in terms of will making in India, some general questions around that. Then move on to what is a private family trust, and for which kind of families maybe a trust is better suited than compared to a will. And pretty much that. And or any questions that you have, as Abhishek mentioned, you can just put it on chat. Either during the session we can take a pause after maybe the will part is over and address those questions, or maybe we can take it towards the end, as in how the session goes. So I think with that context, we can begin. And Shrishti, over to you. Yeah.
Yeah. So thank you, Abhishek and Rahul. And as Rahul introduced, I am an attorney at Will Genie with more than 5 years of experience in estate planning alone. So I am part of the team helping understanding every client's need and then providing a comprehensive estate plan which is customized to their needs. And we plan on it first, and then we implement basically on it. So we are a company who is providing end-to-end estate planning, whether it's pre-death or whether it's post-death. So which gives us an advantage, as in whatever documentation we do. We also see the implementation through the post-death matters, and we see what basically where the mistakes lies, if maybe the documents are coming from attorneys who are not basically in this practice purely, and they have gotten it from some other firm maybe. So we also learn from other people's mistakes. We keep on learning, and we have, I think, not perfected but gotten to a pretty good level of understanding how to provide airtight estate planning documents to our clients. So starting with will, we of course help with will drafting and registration in every part of the country.
Yeah,
Uh,
Shruti, I think
yeah,
just one thing, Abhishek, we can move on to the next slide and then we can talk through the slides. Actually, I think that'll be better.
Sure.
Sorry. Yeah.
Yeah. So if we start with this, what happens without estate planning? Without estate planning, basically there is a lot of ambiguity. There is a lot of confusion. People are left to assume what basically their maybe parents or their spouse's wish was. Personally, I have seen with the clients that when whether they are giving certain assets to one person more, or they are distributing it equally, or they are disinheriting one person as a whole in their will. But when it's coming from that person straight away through their will, families are more susceptible to accept it. But if there is no will in place, if they do not know basically what their last wishes were, then there is a lot of chances of disputes in future. So first of all, what a will does is it communicates your wishes to your family. So what basically you had in mind. So it makes the chances even more good of your family avoiding any disputes after your lifetime. So this is one. Second, there are there is an article in Economic Times that like thousands and crores of rupees are lying with the government because their families do not even know that those assets existed. So what that will does is that it documents what all assets you have, and your family basically knows where to reach out, how to reach out, and how to claim those assets. So this is the second biggest reason that we always recommend our clients to go for a will, right? And many individuals avoid discussing about estate planning, about wills, because they do not want to think about death. Whereas when we talk about, let's say, insurance policies, people have insurance policies as early as 27, 28, and so on and so forth, when they have started inheriting assets. And people usually also say to us that, why do I have a will? I have a small family, or maybe I have a small house. Why should I have a will? I think it is even more important for that person to have a will, because that house is everything for them, right? So they should have a will in place wherein they are expressing how they would want to distribute this particular house, or that the assets that they are having at that point of time, and what are their wishes. It is even more important. So it is a myth that people say that only rich families, how we have seen in movies, how we have seen in media, that only rich people should have a will. No, anybody who owns any kind of asset should have wills. Right now, we are seeing emerging trends for investments like SIPs. People have demat accounts. So to mention that in their wills and mentioning their beneficiaries in the will is very important. There is a myth around between people, which I would like to bust, that nominee is the owner of the assets. So people think that if I have nominated people in my bank accounts, in my FDs, then that's it. I have taken care of it. But no, nominees are basically custodians of those assets. They are not the they are not the ultimate owners or ultimate beneficiaries of those assets. Nominees are just supposed to collect the money or collect the assets from the authorities and then distribute it to the beneficiaries as per the will. But if there is no will in place, then the distribution is followed by the succession laws as per their religion, the religion that they are following. So for example, for a Hindu male, a Hindu succession act will govern how the distributions will be done. For Parsis and Christians, Indian succession law will come into play. For Muslims, Sharia law will come into play. So let's say an Indian male has just deceased and does not have a will in place. Now his assets, whatever the assets he has accumulated during his lifetime, whether he has gotten it through his ancestors, it will be distributed as per the Hindu succession laws. And it says that a Hindu male's mother, a Hindu male's children, and his wife will get everything equally. Now, it most probably it would have been a case that maybe he wanted to give a certain amount or more or less to some person or less to another person. So that could have been taken care of and avoided by if he had made a will, right? So,
Yeah, and just
yeah.
adding to this point over here as well. What happens is through succession laws, right? Through succession acts, the distribution happens to multiple people. So let's suppose there's a family of say 6 dependents. They are the legal heirs of the person that's gotten deceased, and there is no will in place, right? As per the Hindu Succession Act, all of these 6 people should equally get all of the assets that was owned by the person that has gotten deceased, right? Now, if all of these 6 people are not on the same page for whatever reason there might be, right? Things like a property, if that gets distributed among 6 people, if you want to sell that property and get the proceeds and then further your life through that, it becomes virtually impossible for you to do that because you need to get all of the 6 people on the same page, right? So that's why even usage of those assets in the future get difficult when it's not expressed through a will. And more so, as Shrishti mentioned, if you don't want to distribute it equally, then it becomes even further more important that you mention it on your will. And similarly to the point of the nomination, it's only and only a caretaker of the asset. In a lot of situations, for example, your demat, it's always recommended to have a nominee. But the reality of the nominee is that it is more important for a bank or maybe an institution where they can just directly push it to the nominee. So their liability ends as soon as they move it to the nominee, and they don't have to worry about who the legal heirs are. But technically, what happens is the nominee, after they've received those funds, they have to ensure that they move it to the legal heirs, right? So in cases where in the will also the same person is mentioned, which is the nominee, that also works. But a will always supersede nomination, right? So there will be cases where the nominee might be different than the person that is on the will. In that case, it is the job of the nominee to ensure that the assets are moved to according to the way it has been written on the will. So pretty much will supersedes nominations, right? In the absence of a will, the nominee has to ensure that it goes to the legal heirs in equal proportion. And in the absence of a nominee in the first place, the bank will not even transfer it to the nominee or to any of the legal heirs unless and until they get certificates from the court. So all three are important. Nomination is important. On top of nomination, it is important that a will is made where clearly it's depicted who should be getting what. This ensures a tight-lit structure without any disputes within the family, as well as those assets can be utilized in the future because it's not disintegrated into multiple parts. Yeah, Shashi, carry on.
Yeah.
Well, just
So
one query here, because I think nomination typically comes up as a very, very common question. So let's take two cases. In the first case, there is a nominee in place, and that nominee is, say, in case of Mr. X, it's his son, right? So does it mean that the asset is automatically moved to his son, and post that there can be a claim by his daughter or his other son or his wife? Or if the nominee is there, then that is sacrosanct. No one can challenge it.
So, nominee again is the custodian. He's entitled to receive it from the authority. Now, the authority's responsibility is over. Now, it is uh, on his back that he has to distribute it either on the basis of the succession laws in absence of will, or if there is a will, then he has to honor the will, right? So, the other legal heirs. So, let's say there is no will right now. The other legal heirs are wife, children. They can basically claim those assets if the nominee has not distributed it by starting a civil suit, of course. And then they can claim those assets, and then they have to go through the long court process, and then the assets will be transferred to them.
Okay. So this is,
Yeah.
I think this is a very interesting misconception, because
Yeah.
largely, even when we do mutual funds, even when we do stocks, we typically advise
Mm.
people to have a nominee. And
Mm-hmm.
I think everyone assumes that when we have put a nominee there, the asset after my demise will automatically pass on to that person without any other complication. So that is actually not the case. He will just become a custodian for a small
Exactly.
till the other people either distribute it
Challenge it.
according to. And if there is
Yeah,
no will, then that property can actually end up in a dispute in any case.
exactly.
Correct.
We have to have both nominee plus will in place.
Yeah,
Right.
and Abhishek, maybe we can talk about 1 minute when there is no nominee in the first place. What happens in that case as well? Because it's also linked to the entire bit, right? If let's say there's an FD over 5 lakhs, right, in a particular, there's no nominee attached to it. Okay. After the demise of the FD holder, the bank will, even if one of the legal heirs, let's say the son of the father who's gotten deceased, ask the bank that can you transfer it? I'm a legal heir, I'm his son, right? The bank will say nothing doing. You give me a family tree of the person who's gotten deceased. Only and only after that, I will even transfer it to one of you, like one of the guardians or one of the legal heirs that way. And that entire succession, it's called a succession certificate or a family tree structure or a legal heirship certificate. It differs from region to region. But what I'm typically trying to say is that that entire process takes around 8 to 12 months, because it's an entire legal process where you have to file a petition with the court. The court then does various things and then finally gives that certificate out, and then you hand it over to the bank, and then it will go to one of the legal heirs and so on and so forth. So anyway, that process gets even more complicated, not just time wise but effort and monetary wise as well. Succession certificate, typically if you go you ask around, it will cost a family 1.5 to 2 lakhs end to end, including a court fee that is involved. So there's a expense also to it, which can totally be avoided if you plan plan this entire activity well in advance. So just wanted to cover that.
Absolutely. I think super interesting that just having a will also is not enough. You have to have a will. Along with that, you have to have a nominee. And I think most people would not be aware that the consequence of not having a nominee can be so large. I mean, no one was probably aware that 8 to 12 months is the timeline to claim one asset, and probably the kind of cost also involved is extremely high. So I think very interesting insight. Yeah, I think please continue, Srishti.
Yeah. So, yeah, as we can see on screen, there is a myth that I can't change my will once it's made. No, the will can be changed if you want every day, but we do recommend to review your will and change your will every 3 to 5 years if there is a significant change in your life. For example, there is a new kid in the family, or you have just gotten married, there is a new family member in the family, or somebody has deceased whom you were giving a substantial amount of your wealth to, but now you would want to redistribute it. So these
Right.
big changes, when they happen in your life, then you would want to change your will. But otherwise, the will can stay put for 5, 6 years, 7 years, 10 years. But it is recommended to review and change it every 5 years.
Makes
So,
sense.
yeah, without a will, of course, there are family conflicts. As I said, that if it's coming from the horse's mouth, then there are very less chances of dispute. Maybe there are chances that people will respect what that person's last wishes were. So,
True.
putting it out on that paper, on that self declaration, is a much better option. And there is no financial clarity. Because you do not, your parent, your basically family does not know what all you have left behind for them, right? So there are so many cases wherein we have seen that the person's spouse, even their spouse, didn't even know that they had a certain amount of investment here and there. So putting it out on the paper, on that will, is much easier for them. It's a big clarity that they can seek out through that piece of paper. Then, of course, there are no legal hassles because you have put it down that how the distributions would have to be done, as Rahul rightly said, in absence of even a nomination or a will. How things can escalate. Authorities might ask for a legal aid certificate. They might ask for a family tree. There are many steps. They can ask for a succession certificate, which could take about 1.5 years and an amount of 1.5 to 2 lakh rupees, which could be a huge hole on the pocket for some people. So that will avoids those certain steps that would be taken when there is no will, right? Then unfair distribution can also be avoided. So there are certain circumstances in the family that maybe parents have spent a huge amount of money on one child. This is just a hypothetical example. And so because they wanted to go abroad, right? So they have spent crores of rupees on their studies, while the child who chose to stay back in the country with the parents, they might not have spent such a large amount of money on their studies. So they would want to naturally, maybe during the time of distribution in the will, they would want to do an unequal distribution, which they cannot make sure of if they are just saying it by their mouth that, after my lifetime, you do the distributions like this. No, if you are writing a self declaration in the will, first of all, they are legally obligated to follow it, right? And then it becomes pretty clear what the parents' intentions were. So that is why whenever we are doing succession planning through will, we also recommend our clients to talk to their family, talk to their children, that what they are doing and why, what is the thought behind it, why they are doing it, right? So unfair distribution can be avoided through the will.
Yeah.
And
So and just we'll move on a little quickly because of paucity of time.
yeah,
There are
yeah.
I think there are a couple of questions I think which will be important for everyone to cover. So Shyam Suri sir has asked, does it need to be registered for it to be legal? I can just take that up for everyone's benefit. What the law says is that if you have a will and you have two witnesses that have signed the will, a physical copy of the will which is signed by two witnesses, it is considered completely legal and can be executed after the demise of the person who's made the will, right? But in certain cases, we do recommend getting the will registered, right? What does registration mean is that you're basically going to your nearest registrar's office, okay, and getting a sign of the registrar on your will, and a copy of your will is also going to be with the registrar office, right? So technically, it's like government becomes another witness on your will, and the authenticity of your will increases because there is a copy with the registrar office, right? So whenever the asset value probably is on the higher side, or we feel that there could be family complications that can come in the future, or it's a certain region like a Mumbai, Kolkata, where sometimes properties require a probate of a will. Right? In those cases, it's better for a will to be registered, but it's not required. Is what the law says. We
Yeah.
can move on to the next slide. Yeah.
Yeah. So yeah, as a company, we help create wills. So we of course try to understand the client's queries, what his family background is, and then as per that, we recommend them what kind of a will would be best suitable for them. We do take legal consultations also, wherein if there are people who would much rather be face to face while doing these discussions with the lawyers. So we do legal consultations for that, and we help them distribute we do help them structure how they would want to distribute their assets, in what fashion, whether it would be percentage wise, whether it would be asset wise, whatever their wishes are, we legally draft it in the will. We help them choose executors. Executors are the people who implement your will after your lifetime, right? So we do help them understand who should be an executor, and we help them understand that witnesses are also important. We recommend that the witnesses are uh, preferably not from the family, because they do have indirect interest in the will. So we recommend to have an impartial party like a neighbor, friend, colleague as their witness while they are signing or registering the will. And we then help them basically whatever the thoughts that they have shared with us in consultations or on paper, we draft that and we finalize it with the client, and then we help them with the registration in their particular city. So this is the process, how we help our clients.
Yeah. So I'll just take a bit of a pause here
Yeah.
and move on to an instrument which is, I mean, we talked about wills, and wills is probably a lot of people would have some idea about wills. They would have heard it in Bollywood movies. Maybe that's probably the first primary source where this gets sort of called out, like Meri Wasiyat and so on and so forth. But that's a very simple, legally accepted way of transferring your assets to your legal heirs from that perspective. Another vehicle that has gained a lot of popularity in India recently is that of a private family trust. Okay. What essentially happens is a will is a declaration done by a family, by the person who is gotten deceased, that can always be challenged in court. Right? We've heard of so many wills getting challenged, so many assets being in hold of legal authorities because there is a challenge, and that's being contested, and so on and so forth. Um, but in the West, or what's very, very popular as a vehicle which is absolutely secure, is that of a private family trust. In India, it's been picking up. We've been into this. As Virginie has been into succession planning for the last 10 years, but private family trust as a vertical has really picked up over the last 3 to 4 years. So, in a good position to sort of tell you how the dynamics have changed. And one of the bigger reasons for that is private family trust essentially becomes an individual legal entity. So it's like if my father is creating his trust, it'll be called Mr. Shah's private family trust. Okay, it's a completely separate legal entity which has its own PAN card, which has its own bank account, and an independent status of its own. Right? Um, and during his lifetime, my father can move some of his assets or all of his assets depending on his requirement to that of the private family trust. So essentially, the ownership which earlier lied with him lies with the trust. Okay, and every trust has a trust deed, which is essentially a rule book of how the trust should function. Right, after the demise of the person who started the trust, who should it go to? Pretty much everything every rule that you would mention on how the trust should function. So to put it in a easier way, it's like a private limited company, okay, that has certain rules and it works according to those certain rules. Every trust has certain trustees, which are basically managers of a private limited company, and their job is essentially to manage the way the trust is functioning. So the rules are being followed. There is no discrepancy that is happening there. Otherwise, it could lead to a legal action. So it's governed through trustees whose job is to ensure that the trust works the way that the draft has been put up. Right. So with this, what happens is, because it's a completely different legal structure, independent legal structure. Okay, nobody can contest the trust. Right. No, there is nobody can say that according to the trust, this person is getting so much. I am contesting it. This can't be possible. That's not possible itself, because all of this is been legally drafted and has to be executed the way the trust has been written. Right. So you can call this as a very, very airtight form of succession planning, where whatever your wishes are, they have to happen the way you have drafted your trust deed. Right. Um, and the next thing we'll want to cover is a little bit on what kind of families, for example, might want to prefer a trust over probably a will. And again, I'll let Shushti continue. If you can go to the next slide, Abhishek, that covers pretty much kind of families. Yeah.
Yeah. So basically, the kind of families that go for a private family trust is, of course, HNIs and affluent individuals who would want to manage their assets under a trust, because, of course, there will be a family and the number of assets, because of that, there are chances for disputes. So, as Rahul rightly said, if the assets are transferred under this entity, then only the beneficiaries listed in the trust are entitled to those assets under the conditions mentioned in the trust deed. So that is why affluent individuals go for this kind of a trust. They also do business succession planning through these trusts, right? And then basically to protect assets from creditors. This is one of the biggest reasons people come to us for a private family trust, because the trust ring fences your assets against claims, against any creditors. If, for example, you have businesses, you have personal guarantees, right? To safeguard your personal wealth, you enter into this kind of a structure, as it is a completely separate legal entity with its own PAN, with its own bank account, with its own demat account, with its own complete separate identity, right? Then Muslim families also are recommended for this trust, because very interestingly, under Sharia law, you are only allowed to distribute one third of your assets as as per the will. Even if you are making a will, only one third of your asset can go to your desired beneficiaries. So in that case, we recommend them to create a trust now, transfer the assets into this completely separate legal entity, so that they can make sure that their 100% of assets are divided between their desired beneficiaries in the desired manner, right? Then NRIs with families in India. So this is also one of the biggest reasons that we are creating trusts now, because in India right now there is no estate tax slash inheritance tax. But in abroad, in other countries, the inheritance taxes are as high as 40%. Right, and there are many families wherein maybe their child has gone for studies, or the major part of the family, or a smaller part of the family has shifted abroad now, and they have certain assets in India, a good chunk of assets in India. Now whoever is there abroad, when they will be inheriting those Indian assets, they would have to pay a hefty amount of inheritance taxes on those properties, on those assets. So then we do recommend them to have this entity in place, which will basically be a mediator. And the assets, when transferred to the trust, they will not be transferred to your name directly, because you are one of the beneficiary in that trust. So the assets are being in the name of the trust now, not in the name of a single individual. Hence, they do save on the inheritance taxes. So that is why we recommend them to have a private family trust in place here in India. Then families facing matrimonial disputes. This is also an emerging reason that people have been creating trusts. As everybody knows, prenuptial agreements are not valid in India as they are in US, Australia, right? So there have sadly been rise in matrimonial disputes now. So many people have been reaching out to us to create these kinds of the private family trusts, because when you transfer your personal wealth to a trust, that personal wealth that you're transferring to the trust, now the ownership is changing. So whatever assets now are being transferred to the trust, it is subtracted from your net worth. And when the matrimonial dispute starts and then there are claims on your wealth, at least the assets that are taken care of and are transferred to the trust are safeguarded against any attachments in such kinds of disputes. So that is why we do recommend. And there have been shockingly and surprisingly shockingly, there have been individuals that have been coming to us with, before getting married, because now awareness has been growing. So these individuals, maybe as young as 30 years old, they have been coming to us to enter into these kinds of structures before getting married. So I think that is a good start for them to ring fence their assets in advance, right? And then, of course, for philanthropy and charity reasons, people enter into these kinds of structures wherein they say that my primary beneficiaries would be my children, but in case they also cease to exist, or if they also wish, then this is my secondary beneficiary, which is so and so foundation or so and so charity. And after my lifetime, I would want to give a certain amount of money in a certain amount of interval to this charity or to this hospital or to this foundation. So for these kinds of reasons also, people do create a private family trust.
Yeah, and I think one thing that Shashi missed out on was parents with special needs. I think that's
Yeah.
also a very and
Yeah.
probably the most important category. In those cases, what happens is whenever there's a family that has a special need child with them, the primary concern is what will happen to the child after the parents pass away, right? Because during their lifetime, obviously, the parents will do whatever is required and beyond. Typically they assign a caretaker or a protector or a guardian to take care of the child in the future, but that's not legally binding, right? So it is based on just good faith that the guardian will take care of the child's requirements in the future. But with a trust, you can essentially put it to a legally binding term where it is mandatory that the way the trust has been written, the child will keep getting those benefits through the trust, and their needs can be taken care of in the future. Yeah.
Yeah.
So I just want to interject here and just tell people a small story which happened yesterday. So yesterday I was speaking to one of our clients who had invested a lot. So he has a very decent size portfolio, about 30-40 crores type. And he called me up after seeing one of our messages that we are starting estate planning. And he said that, Abhishek, I want to build a family trust. And because I knew him well, so I knew that he has only one son who's almost like 12, 13, 14 years right now. So I asked him कि "Sir, आपके तो एक ही बेटा है, and why do you need to go for a trust? Just go for a will. It's a simpler solution. It'll just cost you a couple of thousand and you'll be done with it." So he said कि boss देखो, I am creating a trust because my son is very young right now, right? And hopefully, if I'm able to grow my corpus in the next 5-10 years to some 100-150 crores type, which is his goal, what will happen if or in an unfortunate event, if I pass away when he is 15, 16, 17, 18? For a 17, 18-year-old child to get assets worth 100 crores, it is actually going to be very difficult for him to approach money logically. No matter how much I try, for a child of that age, he's bound to make mistakes. And therefore, I don't want to put him into a position where he is having access to such a large portion of wealth with no direction on how to use it. And so he said, what I want to do is I want to put my money into a trust and ensure that the trust has a specific timeline. In case of demise, how much money will he get on his 13th, 14th, 15th, 16th, 17th, 18th birthday? And maybe when he's 26, 27, 28, at that point of time, I would like him to inherit everything. But I don't want him to inherit everything all at once, especially if he's at a very young age.
Mm.
So I think that was a very eye-opening conversation for me, where I realized that even apart from these instances where we discussed the family trust, even for people who generally have no complication, but who have substantial assets or are expecting to build substantial assets in the next 5-7 years, a trust with a certain allocation might help you create a very logically structured wealth distribution system for your family of sorts. But yeah, I just want to
Yeah, Abhishek,
add
that's
two
yeah.
cents.
No, that's an excellent point, and that happens with us at multiple points. Whenever there are younger children, and a lot of these is milestone basis, right? So private family trust, we always call it a milestone based event. Whenever you get children, for example, you start thinking about them a lot more than probably yourself, right? That's a shift in mentality that happens. So many trusts that we create where there are certain clauses where the trust, the entire ownership of these assets will only happen after the 25th birthday of the child in the demise of the parents. Obviously, the demise has to happen first and then 25th birthday, but such conditions are always covered as part of the trust deed, right? So this is always communicated with clients, be it special child, be it just children as well. The thought that you brought up is maturity to be able to use those funds. When do you feel that the children will have it? That's how you can sort of structure it. So the best thing about a trust is it's not governed, right? And HUF is sort of governed. So there are certain rules, and those rules are all inclusive, that it can only be those rules, right? In a trust, you are essentially writing your own rules. So people that have we talked about certain cases where it is very very important, like NRI, special need child, and so on and so forth. But people that have made considerable wealth or are in the process to do that, for them it's a very very solid structure where you can mention those rules, and pretty much it becomes untouchable in that aspect. And trusts can go on for generations. So you can have a trust that's going on for 90 years, 100 years, or so on and so forth. So that way, it's a very, very solid structure. So yeah, thanks, Abhishek. Yeah, we can carry on. Yeah. So just a little bit of a touch base on the difference between will and trust. We've talked a lot about it, so might not spend more than a couple of minutes. But basic point is that because trust is a separate legal entity, there's nobody that can challenge it. Okay, with a will, some assets which are very very high value assets, sometimes even if that transfer has to happen, there is a registered will in place. Certain authorities can ask for a probate of the will, which is essentially saying that the will that you're producing in front of me, is this your final will or not, right? Because those assets are of that higher value. So that the process of a probate again is a typical 10 to 12-month process. This does not happen for all assets. So I'll just reconfirm, this happens only for assets of a higher value. So audience that is in Bombay, at least, you would have heard about the term probate a lot, because the property prices are through the roof typically. So whenever property needs to be transferred, right, the society office asks for a probate. All of that is not required in a trust, right? Because again, it's a separate entity from that point of view. And the flexibility is there, so you can change things if all of the trustees, there are certain changes you want to make. If all the trustees agree to it, those changes can be made through the lifetime of a trust. So yeah, it's a airtight solution, maybe not for everyone, okay, but it's a good knowledge sharing to understand what all it can do. So while we look at will only from a end of life perspective, trust can be looked at during your lifetime perspective also, and of course end of life as well. So yeah.
So I think I'll quickly try and cover this portion, Rahul. So basically, like we covered, largely there are 2-3 things which we have to do in estate planning. One is what is simply a basic will, which basically is creating a will, establishing who is going to get what, and it comes into effect after a person has passed away. The other is the family trust, which ensures that you can transfer your assets into a structure right now, and you get an absolute amount of control on how those assets will get distributed. And the key benefit is that it actually shields it from any legal disputes or court challenges. It gives you protection from any creditors, business related disputes, whatever it is. So family trust works well for the situations which we discussed earlier. The third scenario is in for people who have typically absolutely complicated holdings between multiple families, multiple businesses, and those are more customized solutions wherein just a family trust may not do. So that we have just left it into a small bracket wherein we'll have to first evaluate the scenario and then come up with what kind of a solution can be offered. So Rahul and Shrishti are from Will Genie, and that's I think we've covered their introduction in the past. But I think broadly their team has a very deep experience in estate planning specifically. They've done it over the last 10 years, and they have created both will and family trust structures for a lot of people. And therefore, I think this kind of helps us overall complete the entire discussion on what we wanted to communicate to you in terms of estate planning. What does it entail? Why should you plan for it? What are the reasons that you should try and do it now rather than later? If you do want to do it, what are the kinds of options do you have? So should you go for a will? Should you go for a trust? So what we are trying to do is this call was supposed to be an introductory call wherein we introduce the offering and we help you understand what the entire matter is. We'll also drop a link to book a call on the chatbot, and essentially you will be able to kind of book a call there. And on the call, we'll have someone from Maltese, and we'll try to also ask Rahul if we can also get us someone from an estate planning background to come and give us some advice on, say, how can we, for every specific situation, for people who sign up on that link, how could we actually move forward with a will or a family trust creation. And largely, I think the key takeaway is that the time to do this is now, because this is one of the things which we've seen people postpone, and this is not for anyone else but for myself. So we've personally been also thinking about will and trust for a very long time now, and I think every time that I think about it, because it's not urgent, it simply doesn't get done. So I think that is one thing which we need to be a little more cognizant that, although it is not urgent, but it is in the important bracket. So in the quadrant between important and urgent, this falls into a quadrant wherein it should get done. And therefore, I think professional support, proper legal advice is something which can help us do this better. What we can do next is, Rahul and Shushti, if you have another 10 minutes, we would want to kind of quickly take questions from people. Sure. And kind of address some queries. And what we'll do is I'll just take 5-7 questions from the chat first, and then people can probably raise their hands and then they can unmute and also take questions directly.
Sure. Yeah.
One interesting question is, what's the net worth at which a trust makes sense? And I think that's a very relevant question. A lot of people would have understood the efficacy of a trust, but I don't think it will make value for very small corpuses. But typically, what corpus threshold should we keep?
Yeah, sure. So a couple of things there. So what we are trying to change as a narrative is that earlier it was always very, very high corpuses should think of a trust. Now that we've covered the kind of cases that Abhishek and I were talking about, it's more specific to the kind of requirement the client has, right? So that plays a role. But typically we have seen 3 to 5 CR is a good place for you to think about a trust. Right. So I'd say 3 to 5 CR, and that's more only from an asset base, but it should always link to what is the objective of a trust. So there are cases where it could be 20 CR plus as well, and we'll say will is more than sufficient. Don't even go for a trust. So it's more important to realize that trust is more objective driven. If you cleared a net worth of over 5-10 CR, then just to evade it from any sort of problem in the future, maybe trust is necessary. But there are a lot of other cases where, depending on the objective, a trust would be a very, very good solution. So that will be that answer.
One quick follow-up question from my side. Should we also look at a will and a family trust in conjunction, as in someone has both? Some portion into a trust for certain specific needs and the rest of the assets under a general will. Does that structure also work?
Absolutely. I think that's the most common structure, in fact, and there are a couple of reasons why. So when you're moving immovables to a trust, right, there's a stamp duty that gets levied onto it because it's like ownership, transfer of ownership. Right? A lot of cases, what we usually suggest is immovables you can move through a will to a trust, right? Because that's called inheritance. So
Okay.
within inheritance, you don't have to pay any sort of stamp duty or any sort of transfer charges that way. So your movables can be in a trust, your immovables can move through a will through a trust. That's a better sort of setting that way. Otherwise, also we do recommend that if you don't want all of your assets in a trust, that's fine. You just keep maybe some of your movables in a trust, others you can keep through a will. So you're at least ring fencing part of your net worth through that basis, which cannot essentially be touched upon. So all of these structures work. And Abhishek, one more point over here is, for example, for immovables, a lot of them even prefer a gift deed, which is essentially moving the transfership of your immovables during your lifetime to ensure that there are no hassles like probate of a will and so on and so forth after the demise when there is a will in the when the will needs to be executed. So these structures like a gift deed plus trust plus will plus even a power of attorney, which is essentially saying that at a later age, I'm just giving a power of attorney to my child to ensure that everything can be taken care of. So if
Mm.
any sort of health condition comes into play, nothing stops. So it's a mixture that we come up with depending on the requirement of the family and so on and so forth. So yeah.
Absolutely. Makes sense. Um, so there are some questions with regard to will. Let's just take that quickly. The first question is, can can the executor be one of the beneficiaries of the will?
Yeah. Shruti, if you want to take that, sir.
Yeah. So beneficiary can absolutely be an executor as well. So there is no bar in law that a beneficiary cannot be an executor. In fact, we recommend it that whoever are the beneficiaries, you either give them the first position, the second position as per preference, or you give them a joint responsibility to implement the will so that, it is made sure that basically it is coming to them only. So they will do it with more responsibility.
Makes sense.
Yeah.
Mr. Arun Rao wanted to know, can you also clarify what happens if an asset has joint holders? So if there's a bank account where the husband and wife both are joint holders, how does that kind of get treated?
So usually what there is a myth around that as well, that if we are joint holders in any assets or let's say a bank account or even a property, then it will automatically go to the other person, which is not true. The person who is holding an asset and has now deceased, only their 50% of the assets will be distributed, and that too again as per the succession laws or the will. The remaining 50% will remain with that person in their name.
Okay. And this ratio is always 50-50 in case of joint holding.
Correct. If it is specified, then it can be different. But if it is not, then it is implied that it's equal. Yeah.
Yeah, so dependent on how it was conceived in the first place. If
Correct.
it was a 50-50 ownership, so what basically we're trying to say is essentially whatever the ownership is, which we are not aware, but whatever percentage the ownership is, only the percentage that is owned by the person who's gotten deceased, only that percentage is liable to be transferred according to
Correct.
the will or so on and so forth. The other percentage, which is with somebody else, that remains.
Correct.
Makes sense. Perfect. There's an interesting question with regard to will, which says that so there is no will and there is no dispute in the family. So can the people who are now living survivors distribute the fund as per their consent?
Yeah, so that's very interesting, and we see so many cases like that. Again, I'll go back to institutions, right? What happens is it depends on the assets, type of assets, right? If there is an FD above 5 lakhs, okay, those institutions think, will say that this is a high net worth FD, right? So even if it's a single child, there's a family single child, right? They will still ask the concerned people to provide a succession certificate or a family tree. Okay. So it does not matter if there are no complications within the family. If the institutions work along that particular way, that only and only once we get a succession certificate will we transfer those assets, right? That complicated succession certificate procession would only take you 10 to 12 months, which will be an unnecessary burden in this whole thing. And Abhishek, this is something that we keep getting from a lot of families, saying that we have nominees in place, we are a small family, there are no family complications. Why is even a will required in the first place? This is one of the most important reasons why a will and a nominee in conjugation is required, even for simple assets, simple family structures. And you can do a simple will. It's not a very complicated process. It'll max take you an hour or 2 hours to get it drafted if you want to do it online, or maybe a couple of days through a lawyer. But if you do that, it essentially takes care of any such scenarios that way. And the other thing is, when it comes to a property, right, you can always do a family settlement deed, right, to ensure that you are saying that one of them is releasing their rights, the other two are maintaining their rights, and they're okay with it being a 50-50 distribution. But that's also subjective. It depends on the society offices. Some will take it into consideration, some will not take it. But if somebody is absolutely going by the book, then they'll require a succession certificate, which will take a long process. So there are means and ways to probably figure an elegant solution out, but it is very, very subjective. The most elegant is getting a will done.
Perfect. And a follow-up question to that: if someone has in fact made a will, then in that case, there is no requirement to get a succession certificate.
Succession certificate is a family structure, essentially, of the person who's deceased, right? So there's no requirement, because in the will you're mentioning this asset should go to them. So that has to be honored, right? But sometimes, even if somebody is asked about probate, right, that I'll answer through this. So if there's a will and there is an asset like a property in Bombay, right, which is a part of that will, sometimes society offices will ask for the will to be probated, which effectively, what is a probate of a will? I'll just touch upon that for a minute and a half. You can write n number of wills during your lifetime, right? But when you are getting your will executed, basically your final will should get executed. Okay. So if, let's say, my father has a property, he's put it on his will saying that Rahul should get it. After the demise, if I am executing that will, I go to the society office saying that my father has written a will, I should be the legal heir of that will as is written on the will, right? The society office will say that all of this is fine, but this is a very high worth asset. I would want to know if this is your father's final will. I can't declare it right now just looking at this will. So in those cases, and these are very specific, this is not all cases, so that's a disclaimer. Only in specific cases, essentially with properties or generally with assets of a very high net worth, right? The concerned authorities might ask to get that will probated, which is again a court procedure where the court basically puts a stamp or certifies that this is the final will. Every authority can consider this will, and basis this will, they can execute. So yeah, those are the two parts.
Understood. Perfect. Leading on to a question about, on a similar note, there are three types of wills, right? One is an unregistered will, one is a notarized will, and one is a registered will.
Yeah.
So how does the three of them interplay, and which one is more suited for whom?
Yeah, I think Shrishti can answer that, but just a very, very brief context on it. I think, like I said, if a will needs to be probated, right, in that case, if a will is registered, the chances of that probate process being a little smoother is more guaranteed that way. Actually, I'll only take out, not a problem that I've started with the context. So when you're registering your will, essentially, like Shrishti was saying in the past as well, that's basically one of the copy of your will is with the registrar's office, right? So it's already more authentic. I mean, if someone wants to contest it, the government or the registrar office will say that I already have a will. On what basis are you contesting it? So there has to be some really, really solid reason for it to be contested. Right? On notarization, I think Shashti can add if there is any difference between an unregistered or a notarized will. Yeah.
No, I think a notarization is not needed at all. You either get it registered or you do not get it registered. You just sign it in the presence of two witnesses and you keep it at your home. And when it is registered, the government becomes third party, the third witness to your will. So it provides more authenticity to the will. So tomorrow, nobody can come and claim that this person was not of sound mind while making this will, or they were not of good health while making this will, because that person has practically gone physically to the sub-registrar's office along with two witnesses and gotten it registered. So it's, always better to get it registered.
Okay. So it's either a registered or an unregistered will. And
Exactly.
if you want a more clear-cut process in the future, you should register it, because then the government is a party to your will and
Absolutely.
because there is a lot less complication in the future.
Absolutely.
And just one more second on registration. It's not a complicated process. Most of them think
Yeah.
that registration is a long drawn, complicated process. It's not. I mean, and this is, I'll talk a little bit about what we do at Viljini, but this is just sacrosanct across however you want to do it. Right? It's essentially you have to go to the registration office and just give your signatures, a thumb impression, and a picture, and that's pretty much it. We have tie-ups with agents all over the country, so we can assist you end to end and ensure that maximum 30 to 45 minutes of your time is required, and we can do it at your nearest sub-registrar's office. But if you want to do it yourself also, absolutely not. It's not that big of a problem to sort of do it, but the kind of benefits it has outweighs the effort that is required.
Absolutely makes sense. There's a specific question. If the will is in favor of an elder son, does the elder son require NOC from the younger son in order to sell the property?
So, no, NOC is not required. Of course, it depends on state to state and authority to authority. But we haven't seen cases wherein there was a will which was properly registered, and then also an NOC was required. NOC is required in case there is no will, and then you are, as you mentioned about a case where they were together transferring the property to one person. In that case, an NOC is of course required.
Makes sense. Perfect.
Yeah.
With regard to family trust, there are a couple of questions which altogether sum up that. Is there a way that trust helps in effective tax planning?
Yeah, I think again, Shrishti can take this up.
Yeah. So usually people do confuse it for a tax planning tool because it resembles an HUF, a Hindu undivided family structure, which was previously with our previous generations was being used for tax planning. But this is not at all a tax planning instrument. At most, it can be a tax neutral structure for you for certain kinds of structures. But basically, estate planning is mostly for smooth succession of your assets and ring fencing of your assets, and the number of reasons that we had mentioned that people create a private family trust. So it is mostly an objective based structure that provides a smooth succession of your assets and basically legacy planning or business succession planning. So I would not at all consider it a tax planning tool.
Yeah, so it's a tax neutral tool. Effectively, all the taxation that is present on an individual, okay, though it's pretty similar to that. So like a long-term capital tax gain, short-term capital tax gain, it's taxed on the trust rather than an individual. But the percentages, everything remains the same. Someone's mentioned it that on our website we have mentioned that it helps in effective tax planning. That comes into play when there are NRIs in place, when they have certain assets in India. In that structure, it does help them in that context. But if you have all of your asset or holdings in India, it's a tax neutral structure. It helps only and only from smooth succession perspective. Everything else remains that of an individual. So all the taxation you're paying as an individual, the trust will be paying that.
Yeah.
Got it. Makes sense. So let's also just take some questions by some of the hands which have been raised. So Shyam sir, if you want to ask some questions, I think I've taken up some of your questions, but in case some are still unanswered.
Yeah, thanks for taking my question. Am I audible?
Yes, sir,
Yes.
please.
So let me put my case itself. I think even though I registered for a one-on-one call, let's say you have a mix of real estate and stocks, let's say kind of, and then also new instruments like AIFs and all this kind of stuff. Let's say it's on multiple names. In your house, there are 4 people, and then you are kind of optimizing, and then let's say decent net worth, so kind of so to say for a trust, and then but if the second I transfer it to a trust, let's say you get let's say 2 people, or wife and husband, are sharing the kind of tax burden one way or other because both have assets. So if you transfer it to one trust, won't it become tax inefficient? That's one of the kind of queries, because only one trust will be paying all the tax, or does it make sense only to do only for removable assets and through a will and a kind of a tax kind of a structure. And the third thing which I just want to have is that what is this joint will? Because let's say, is there anything wife and husband can do a joint? Because there are a lot of properties where they are actually joint, even though the nominations and everything are impeccable, but this 50-50 thing comes. And you are absolutely right that I have only 50% of the kind of thing also. Even though in case of demat, it's easy, but in case of I would say real estate, it's a bit tricky.
Sure, sure. So I'll just try to answer all of the
Yeah,
questions.
thank you. Yeah.
Yeah, thank you so much for the kind of detailed questions. So the first thing that you mentioned is from an effective tax planning strategy, when if it's multiple people holding multiple assets and then you're moving that to a single trust, right?
Yes,
So
yes.
in that case, we do mention that you can create multiple trusts too. So it becomes a very subjective case one-on-one, where what is the objective that you're doing the trust for? That's why objective again becomes very, very important. If your sole objective is tax benefits, in that case, then we can create a structure wherein for example, each trust has a settler, right? So you can create multiple trusts as well with different settlers being those trusts. The beneficiaries can be common across trusts, so that can be figured out as a structure. Right. So that's the answer to the first question, or the two couple of questions around trust. About joint wills, and it's very interesting. I think most wills in India are joint wills, right? It's basically husband and wife. The multiple properties are jointly held by them, but more importantly, even the wishes are in joint, right? So if anyone asks my parents, they'll tell the same thing. If any one of us, if one of the spouses expires, everything should go to the other spouse and then to the kids, right?
Absolutely.
Absolutely, sir. So in that case, a joint will is essentially what that the assets held by both the husband and wife are put down in a single will. Okay, and it's mentioned as a part of the will drafting that after one person demises, it goes to the other person. After the death of the other person as well, it goes to the beneficiaries, which are the children in most cases. And so one will it gets executed twice. First on the demise of the first spouse, second on the demise of the second spouse. Right? And it takes care of the family. It takes care of the entire family that way. So it's a very common choice. A lot of them, in fact, go for joint will. So.
Okay, you can help us, some of your clients, with this kind of, because this is, because a will is more like, I'm pretty commercially smart, it's straightforward, but how this gets executed twice and then what happens, probably there is a bit more complication there.
No, absolutely, sir. You've set up a consultation. I'll tell you everything that we can help you with through it, and we do a lot of pretty much. I'll just give you in terms of numbers. Out of 5 wills we draft, 3 or 4 wills are joint wills. Right?
Amazing.
So yeah, it's a very, very common concept in India, and we also recommend, because again, times are changing. It's not that the head of the family is the only one working anymore. It's a joint responsibility going forward as well. So this is only and only going to get more popular going ahead. So yes, sir, we can assist you once we get on that individual call.
Thank you. Thanks for your time. Thank you so much. Bye. Yeah.
Thank you, Shamsud. One quick question following up Shamsud's query, Rahul. Say if I bought an asset at $100, now the market value of the asset is $800. Say it's a piece of equity, not a movable asset. And if I transfer it to a trust, so do I have to first pay capital gains on that and then move it? Or how does that piece work?
Yeah, so there are two parts to it. One is direct equities, which is your demat account. The other is mutual funds. Demat accounts can get directly transferred to the trust, right? So there's no transfer fee associated with it. So the capital gains is on the cost that you've incurred at the first go. But when you're transferring mutual funds, essentially, because trust is an independent structure, you have to first liquidate it and then open up the new mutual funds as part of the trust. So that hit you'll have to take of paying the taxes before it's moved to the trust. Ashish, you can add if I missed out.
Equities in demat can be moved without any additional tax outlay.
Yeah, so demat to demat transfers can be done from a personal demat to basically a trust's demat without any capital gains, without any gift tax, because it is considered a gift from you to your private family trust. Just like you give a gift to your blood relative, it is considered just like that. So that is why it's exempted from gift tax or any capital gains.
Perfect. That's very helpful. Okay. Taking the next question, Mr. Ugrabhai Patel, if you want to go ahead.
Yeah, hi. I'm Ugrabhai's daughter. and I'm a chartered accountant by profession. So I had a question whether the agricultural lands owned by me can be shifted to the private family trust, because private family trust is not an agriculturist. Also, the question related to this is my husband is a non-agriculturist. I'm a Patel, but my husband is a Jain. So he is not agriculturist as per the law. So can we do a joint will in which I give this agricultural land which passes to him after my demise? Is it possible? Because he's a non-agriculturist.
So basically, some state governments do prohibit to transfer an agricultural land to a trust or to an individual if they are not a farmer. So I do know about Maharashtra, that in Maharashtra, if any agricultural land falls there, then it is not allowed to be transferred to a trust. But in some state governments, they do allow it. We have done it for certain clients. So of course, it would depend on where that the locality of that agricultural land is.
So do you have any idea about Gujarat and Maharashtra?
Yeah, for Maharashtra, it's not allowed. For Gujarat, we can always check and get back to you once you book a consultation with us.
Okay. Another
Yeah.
thing is this private family trust is a perpetual entity, right? So how does it get closed after all the distribution is done? Like my daughters are in the they are NRIs, so I would like to have them, all my properties get transferred to them without them bearing the inheritance tax.
Sure, sure. So it can be for it is not a perpetual entity. It can go up till 3 generations, which is 90 years. And you can always have an option in the trust deed that the existing surviving trustees and beneficiaries can decide to extend this trust further. So it can go up on and on and on as long as the trustees decide to carry forward with the trust, right? And the second question was?
So they are, my daughters will be NRIs.
Mhm.
So how do they close? Because they won't be
Oh,
living here. It will be very
correct,
difficult for
correct.
them to manage the entity here in India.
Yeah. So it's always recommended to have one Indian national trustee at least in the board of trustees. So anybody from the family back home can be one of the trustee to handle the on ground support, to provide on ground support. Or if there is no individual that you would like to give this responsibility to, there are always companies, professional trusteeship companies who do provide these services. And in regards to the termination, for termination, you have to, once you get into a process of drafting with us, you tell us when this trust can be terminated, whether it will be event based, whether it will be age based, year based. You can say this trust will be terminated in 2050. This trust will be terminated when my youngest child turns 18 maybe, or 25, or when my eldest child will get married. These are event based, time based, or you can say that it will go up till 90 years. And then there will be an exit clause as well, wherein you can say when the trustees and beneficiaries are in consensus, then this trust can be terminated earlier also.
Okay. And
Yeah,
how does, you explained earlier that it helps the NRIs to avoid inheritance tax. So how
correct,
does this
correct.
work?
This works as in because, for example, I have my children abroad. Now, when I will decease and whatever I will pass on to them, they are residents of that country. So they would have to pay inheritance taxes of whatever they are receiving from me. But if I'm creating this Indian entity in between, the assets are now being passed on to this via my will, or during my lifetime, I've already taken care of them. So I have transferred my properties, my assets into this trust. And in this trust, my children are the beneficiaries. So they are indirectly getting benefit out of it. But directly, the assets are not being transferred in their name. Hence, they are saving on the inheritance taxes.
Yeah.
Okay.
So
So whenever the properties and everything is sold from the family trust, they will be
Mhm.
getting the money, right? Or
Yeah,
they can carry on perpetually, like to hold the share, lands and everything.
exactly. Exactly.
And their children will become the beneficiaries, or they have to change the.
Absolutely.
Okay.
Absolutely, that can be mentioned in advance in the trust deed that their lineal descendants, basically your lineal descendants, your children, grandchildren, great grandchildren, can become beneficiaries to this trust.
Okay. Thank you so
Rahul,
much.
you were saying something. No
Yeah.
problem.
Yeah. No, essentially on that inheriting tax only, it's country by country, but essentially what a lot of countries are now saying is it's on the global net worth of an individual, right? So any asset they own in India sort of adds to the global net worth essentially. So the rules are again very, very country specific, but if it's in the format of a trust structure, it belongs to the trust and not the individual. So till the, I mean, in that ways, it helps to avoid any complications as well at an initial stage where these laws will only get more and more complex in the future. Is what our understanding is. Yeah.
Correct.
Makes sense.
Thank you.
Thank you. Mr. Surendra, if you want to go ahead.
Yeah, sure. My question is with regard to nominee, custodian, executor. I mean, there are sort of so many terms around here. It's clear that the nominee is not the inheritor. Inheritor is as described in the will or the trust or whatever. But nominee is the custodian, right? Then why do banks and other financial institutions request for percentage to be marked against a nominee? Like I say, wife, nominee number one, 50%, daughter number one, nominee two, 25%. That doesn't make sense if they are only custodians and not really inheritors. So that's question number one. And the question number two is, in ordinary case, is the nominee the custodian and also the executor, or executor is somebody else then?
Executor is a separate person.
Yeah. So executor is more from a will perspective. Anybody that is essentially executing that will, that is called an executor, right? In the will, the nominee and the beneficiary can be the same thing. So let's say my father has put me the nominee for one of his demat accounts, right? And in the will also, I am only named as for that particular asset. That can happen. There is no problem. I can also be the executor of the will. So essentially, the same person can be all three, but rules wise, it's different from that perspective. What you mentioned on the percentages, right? That we'll have to get back on why is that allowed in the first place. That's something that probably I'm not aware of at this current point in time. We'll just check and get back to you on why this is even allowed in the first place, or what is the significance of it. But in conceptually, it will still always nominees that of a caretaker itself. It's not of that of a legal heir. The legal heirs can be different from the caretakers.
Okay, got it. Thank you.
Thank you.
Perfect. Rahul, let's take one last question from Mr. Cham, and then we'll kind of end the call. Sir, if you would want to go ahead. Cham, sir, if you can unmute and ask your question.
I just want to ask one question, just probably I missed it.
Yeah.
While transferring the immovable assets to trust, do I have to pay stamp duty? So apology if I have already covered it, but do I have to pay stamp duty when I'm transferring it to trust?
Yes, sir. So, yeah, you have to, because essentially you are transferring the assets to a different person, right? So it'll be you'll have to pay stamp duty. There's structures around it to probably. I mean, that's why sometimes we do a will plus a trust, wherein the immovables can be moved from the will to the trust. In that case, it becomes inheritance, and you don't have to pay stamp duty. So there are. I mean, that's why we do a more a one-on-one conversation to understand what is a good structure for a particular family. But if you definitely want to move it to a trust right away, then you have to pay stamp duty.
Got it. Okay. Thank you. Thanks for your time.
Perfect. I think let's take a pause here. The questions will keep coming in, but I think at some point we have to kind of end it for the call. But I mean, the link to the booking the call is being shared in the chat. If there are some questions which we have not been able to answer as of now, please feel free to book the call, and we'll try and schedule a one-on-one meet with each one of you, and then try and answer those questions more specifically. I would like to thank Rahul and Shrishti for taking time out and sharing such an informative session with us, especially for something which it is so relevant and so important, but essentially I think 90-95% of the people are clueless about it. So while we spend so much time, building our lives and building a wealth corpus, I think less than 1% of people actually spend time on ensuring that it's put to good use after they are not there. So I think it's a very, very relevant topic. We'll keep trying to get more and more insights eventually over the next couple of months and see how things move. But as of the moment, what we've done is for all of our pro clients, we have created a free will drafting service for all of our Pro Max and Pro Plus clients. So please, if you are interested to get a will done, or if you're interested to get a legal consultation done, please feel free to book a call. We'll do an introductory call and then we'll help you organize your first will. Will is an easier step to kind of get started and understand how to dip your feet into the water. And then you can look at more complicated structures basis what comes out of those conversations. So this is something which essentially takes a little bit of time, but I think it's very important to get started. So on that note, I would again like to thank Rahul and thank Srishti for being on the call. And I also thank everyone else for joining in and spending the last 1.5 hours with us. It was a pleasure speaking to all of you and to kind of try and answer whatever questions you had. I wish you guys a great weekend and a great week. Thank you, everyone, and take care.
Thanks.
Thank
Thanks,
you.
Abhishek.
Thank you,
and
Abhishek.
Thank you.
Thank you, everyone. Yeah.
Thank you.